Welcome to this edition of Counting on Law. Today, we look at how India's courts are responding to questions of reproductive rights. In recent years, the law has taken on a more pro-autonomy color in matters of abortion. In March 2021, India passed a landmark amendment to the Medical Termination of Pregnancy Act that significantly expanded access to legal abortion, especially for survivors of rape, minors, and women facing exceptional circumstances. 5 years on, as some of the most sensitive cases of this kind have found their way into the courts, has the spirit of India's pro-autonomy jurisprudence carried through to how courts actually decide these cases? Using the Prophecy's database, we examined 200 plus cases before the Bombay High Court and find a silver lining. When it comes to medical termination of pregnancy, the court almost always provides timely relief to the litigant. In the lingering spirit of International Women's Day, this statistic is worth paying attention to. India's Medical Termination of Pregnancy Act was enacted in 1971. Under the original law, a pregnancy could be terminated only up to 12 weeks with the approval of one doctor, extendable to 20 weeks only to preserve the life of the mother. The amendment in 2021 significantly broadened this framework. Up to 20 weeks, a single registered medical practitioner's approval is now sufficient. Between 20 and 24 weeks, two practitioners must concur, but the window is available only to specific categories of women: survivors of sexual assault, rape or incest, minors, women with significant disabilities or mental illnesses, and other women in similar vulnerable circumstances. Beyond 24 weeks, a pregnancy can be terminated only if a medical board approves it, and only when there is a serious abnormality in the fetus. Where the medical board declines, or where doctors seek judicial clarity in particularly sensitive cases, the woman has only one path left: to file a writ petition before a High Court or the Supreme Court. In these moments, the court becomes the only place a woman can turn to when the statute itself offers no clear refuge. So, how do these desperate cases play out in court? Using the Prophecy's database, we identified 232 such petitions filed before the Bombay High Court between June 2021 and December 2025. 71% of the petitions were filed beyond the 24-week statutory limit. In most areas of litigation, it's hard to define what an appropriate case duration looks like. But termination petitions operate on a biological clock. Every day spent in legal limbo is a day the petitioner loses to decide her own future. And in these matters, the judiciary appears acutely conscious of that closing window. The median disposal time of these cases is just 4 days. In other words, half the petitions are resolved within 4 days. 85% are disposed within just a week. Many of these petitions are even listed first on board in the day's cause list, ensuring that they are heard at the earliest opportunity. The few cases that take longer are typically those in which the court cautiously keeps the petition pending through the remainder of the gestation period. This allows the court to intervene quickly if medical circumstances change. And in many of these circumstances, as expected, the court permits termination because of substantial fetal abnormalities. But this is far from the only ground. Petitions involving rape or sexual assault, serious risks to women's mental health or physical health, and cases involving minor petitioners are also frequently allowed, often on overlapping grounds. What's clear is that the court frequently goes beyond the 24-week statutory limit, granting relief on constitutional grounds that extend beyond the framework of the MTP Act. This approach is consistent across different benches of the court and in many ways reflects the downstream influence of the Supreme Court's pro-autonomy jurisprudence on reproductive rights. In several instances, the court's intervention extends beyond the order permitting termination. Where financial hardship is involved, the court has directed the state to arrange shelter homes and medical support and to provide neonatal care at government expense should the termination procedure fail. In cases involving rape or sexual assault, the court has also directed authorities to extend support under the Manodhairya scheme. There are, however, a few instances where the court appears to have departed from its otherwise consistent approach. In one order from August 2023, the court declined termination on the ground that the presence of a fetal heartbeat, combined with the absence of a medical determination of risk to the mother, meant that, with due regard to the rights of the unborn child, the pregnancy should proceed to natural delivery. The court did direct the state to arrange shelter and extend medical care, but it downplayed a crucial fact. The petitioner was only 13 years old and a survivor of penetrative sexual assault. The court cited its own precedents, cherry-picking instances where termination was denied, even though, as discussed earlier, such denials are very much the exception. In a similar case, X versus State of Maharashtra 2024, the matter ultimately reached the Supreme Court, which reversed the Bombay High Court's refusal to permit termination. Although these instances are rare, the stakes in such cases are extraordinarily high. In 8 cases within the dataset, the court declined termination despite the medical board recommending the procedure, on the grounds of fetal viability. Such outcomes stand in contrast to the broader trend in the data and to the established legal position that courts generally defer to medical expertise in these matters. On balance, the data tells a reassuring story. 9 out of 10 women who approach the Bombay High Court receive permission to terminate their pregnancy, and they receive it quickly. Yet, for the remaining 1 in 10, the outcome may fall short of the constitutional promises they are entitled to. Even so, the broader trajectory of this jurisprudence is a bright spot, not just for India, but even in global terms. Our analysis focuses only on the Bombay High Court, but if similar patterns hold across other courts in the country, 2 lessons emerge. First, a strong pro-autonomy approach to abortion appears to be taking shape across India's constitutional codes. Second, this judicial experience should inform legislative reform. For every woman who manages to reach a high court, there are likely many others whose journey ends at the medical board. They may lack the time, resources, or awareness needed to approach a constitutional court. One way forward would be to build on the approach adopted by higher courts and create a statutory right of appeal before district courts, bringing relief closer to where it is needed. Indian law has come a long way in championing reproductive autonomy, but justice without uniformity is not yet justice as a guarantee. That remains the work ahead. Thank you.